Papa. Papa. Hello, everyone. Like the video. So please. Also, oops. So I'm just writing some the rumble. Have a get cracking. We will get yeah. Where's that going now? There we are, posted that. Let's just copy and paste the bad boy, ready for later. That's there. Cool. Right. I'm not gonna hang about. We're gonna crack on, guys. So with that, I'm gonna oh shit, wrong one. Gonna press play. I think there's like 30 seconds. I think a shadow banned a little bit as well, I think.
And then we'll see how long that takes us. She's on her way, and then we'll figure out the timeline from there.
And I think what we're trying to do is maybe work through.
Aidan Fauci's mother.
Okay, that'd be fine. All right. So we'll table the defense's first motion. All right, so we're just gonna table that for now.
Oh shit, where's
And
the
that gives us
audio?
the
I
state's,
hope the audio is working.
the state's motion. I also received defense's second motion on the
No subtitles. Oh no.
Yes, we can handle that one first if you want. I can just briefly respond.
Sure.
My understanding, I talked with this morning, I don't believe the state has.
Well, let's see if you can hear them.
But I believe there's some things Ms. Hunt wants to put on the record.
All right, that'd be fine.
Yes, Your Honor, in Crystal Smith case.
Don't even know where she is. But if not, I'll just.
Any autopsy photographs. But it's quite different factually from our case.
No, right. Right, there's something wrong. Is this one on? Let me just look at my audio. Hello, hello.
Case, I did not intend on, excuse me, admitting any autopsy photographs.
No, something wrong here. Right, let me try you without this then. This is on Facebook for a second. Not Facebook. They go on YouTube for a second to check. My channel. That's my channel. That's weird. Oh no. It's playing. Let's see if you can hear them. If I turn it off now, hang on.
And any.
Jeez. If not, I'll just. Right, I'll play it now to see what happens.
Crime scene photographs. But I do think what would be fair to explore.
Play it now to see what happens.
And perhaps the case agent is just simply, I don't want to be limited on stating a brief description of the crime committed against Ms. Bailey and the fact that blood was, present in and around the body, and obviously on the other pieces of evidence, in the room that we're gonna discuss as part of the testimony. So long as I'm not limited in that respect, and there's no argument that the state didn't, prove or show how much blood was on scene, and there would be no need to actually show photographs, of autopsy or her in the woods or anything like that. And so when he says crime scene in this motion, I believe he means of Miss Bailey in the woods, not the bedroom of Mr. Faucci.
All right.
That is correct, and I have no objection to what Ms. Dutton proposes. I think, depending on how brief that description is, it may, if it's brief, no objection, but if it starts to wade into territory that I believe is prejudicial and takes on a 4 to 3 element that is where its probative value is substantially outweighed by the dangers of unfair prejudice, I may lodge an objection, but describing the nature of the underlying crime, the evidence that was generated as a result of it, that's fair game, and they have their theory of defense just as the defense does. Theory of prosecution just as the defense has its theory.
All right. Based on the stipulation of counsel, the court will grant the defense's second motion in limine regarding photographs of the decedent, which is what is styled as. So the state will not be introducing any photographs of the decedent at the crime scene, nor any photographs of the decedent at the medical examiner autopsy. And the state is not precluded from certainly presenting testimonial evidence or other photographs of other, scenes that were including the bedroom of Mr. Faucci. All right, we'll take up any 4 or 3 objections as we proceed during the trial. All right, so that resolves that matter. We have the motion in limine filed by the state to exclude any argument that the state must prove the defendant actually altered or destroyed or prepared the DNA results in this case. I'll review that motion. Ms. Dutton?
Yes, Your Honor. I'm just gonna approach, if I may, and provide the jury instructions, as Your Honor may have already reviewed, but essentially, the court's aware that the state has to prove 2 elements for this charge. One has to do with the knowledge of the defendant in any sort of investigation that may be forthcoming by a law enforcement agency. The second element is the crux of this motion in limine, and specifically 2A. And that element is that the state must prove the defendant altered, destroyed, concealed, or removed any record, document, or other item with a purpose to impair, in this case, the theory would be its verity or truth in such a proceeding or investigation. It's not availability because we obviously have the item in question, the genes. Essentially, Your Honor, the state filed this motion to prevent the defense from going essentially further than that, or holding and arguing that the state hasn't met its burden on element 2 by not proving or being unable to prove that Ms. Smith actually altered with the results, any DNA testing results, any outcome of the case, any evidentiary value of said item. The crime in this case, as shown by these 2 elements, was complete after essentially the washing of the genes. The crime was complete. If presuming the state can prove element 1, the knowledge of the investigation, and element 2, that she did alter said genes, or the blood on those genes, that crime is complete. The law does not require that the state prove that a defendant altered the outcome based on those actions, any results therefrom based on the actions of altering, destroying, or concealing an item, and therefore any argument to the jury that the DNA results were not affected, or we cannot prove that they were affected, would just be improper and misleading the jury on what the law actually is. Matter of fact, if we were here and the facts were exactly the same, and Ms. Hoover was in fact able to obtain Tristan Bailey's DNA on the genes and Aidan Fauci's DNA on the genes through technology and through the science of DNA, if that in fact had still been able to occur, we could still be here. We would still be here. She still altered those genes by the act of washing them with the intent to impair the law enforcement's ability to use them in an investigation. So the converse is therefore true, Judge. It doesn't matter whether or not, under the law, someone's successful in ultimately altering any sort of investigatory route or evidentiary value of an item. The crime is complete after the act of, and then the various options that you have in element 2A. And so I provided a few cases, Your Honor, in my motion that a lot of this case law actually isn't specific to our facts, but the law that the cases discussed is helpful. A lot of this case law has to do with actually the discarding of evidence, the swallowing of narcotics, and a lot of this case law is built upon those things. But the crux of explaining what actions the law criminalizes is very helpful. And in Chapman v. State, 36 Southern 3rd 822, it's a 50 CA 2010 case. It's one of those drug type cases, Judge, but the court's very clear that the statute punishes the damage, destruction, or concealment of physical evidence in an effort to prevent its use. And so if, the state is going to be required to prove that Crystal Smith altered, destroyed, concealed, removed blood from these, from any item, in this case would be the genes. So that is in fact what we are required to prove, and how that ultimately impacted a case or produce a result, in this case DNA. The state just noticed through deposition and then perpetuation in this case, a lot of time is being spent by the defense on the ultimate issue of results, and we just don't feel that that is a proper argument for the jury, and it changes the state's burden on what we have to prove in this case.
So let me just ask you the question, because you're touching on the genes and the blood. So I want to be clear, what is it that you agree that is the state's burden? Is it the altering of the genes by washing them, or was the intent to alter or remove the blood by washing the genes?
Well, Your Honor, I
Or
believe.
is the evidence the genes, or is the evidence the blood on the genes?
I think it could be both, and I very well amend my information to include blood and genes, or add the blood in, because in theory, Your Honor, she absolutely altered the genes. By washing the genes in their current state, they were altered. She also, our argument would be, destroyed and removed blood. So I may need to amend to cover that. But what is not the law is, because of her actions, what did that do? Did that change any results? Did that change the DNA? And it sounds like you're splitting hairs, which you kind of are, but we're not alleging or charging that she did anything specifically to DNA. It's the object of the genes, the item, and then arguably the item of the blood. So that is our theory. She altered the genes, she removed the blood. It doesn't matter whether that made a difference in the case or not. Ultimately, that's the state's argument here.
All right, thank you. Jurors? Your Honor, it's the defense's position that this is a matter that's squarely within the province of the jury, and by granting the state's motion, you're denying the defense one of its viable theories of defense by arguing that whatever conduct occurred, it didn't impair the availability of this evidence. That is squarely in the jury instruction, and that is a matter for the jury, and to deny it would be denying defendant one of her theories of defense in this case.
Let me just interrupt you. I want to make sure that I'm clear. I didn't take that their motion was to limit your ability to ask or to get into whether or not the DNA was on the item or was not on the jeans, what happened. It's just the argument that that was what her intent was, and that that's what they would be required to prove, was that she intended to remove DNA. Am I confused about that argument from the state? That the point of this motion is that you can't come in front of the jury and say that in order for the state to be successful, for them to prove their case beyond reasonable doubt, they have to prove that she intended to remove DNA from the genes. Is that not what this motion is for?
Right, I mean, we would never, ultimately, I believe that her intent was to remove blood, which may or may not remove DNA, and that might have been her intent, but the state would never be able to prove, and I didn't allege that I'm specifically charging removal of DNA, because if she did in fact do it, I would never be able to prove that it was there in the beginning, if that makes sense. The item of evidence that was of value that she altered with and changed its original form had it been found by law enforcement is genes and or blood that was present. Even if, there's as your honor knows, there's cases wherein blood is present and we may or may not be able to get DNA. The reason the charge exists is to thwart people or dissuade people from altering and changing and messing with evidence.
Let me allow Mr. Contreras to continue with his argument. I just want to make sure that I'm clear as far as, so what you're suggesting, Mr. Contreras, is certainly I would not be in agreement that you could not introduce evidence of what happened with the DNA and whether or not there was DNA on the genes. And I think there's some other measures we're going to have to get into later, obviously, as it pertains to that. But go ahead and continue with your argument.
But and along that vein, Your Honor, the state's furnished the parties in the court with the jury instruction. And let's be mindful, it is the state's burden, and we have the ability to contest each and every element of the case. To prove the crime of tampering with physical evidence, the state must prove the following two elements. The defendant knew that there was an investigation by a duly constituted law enforcement authority that was pending or about to be instituted. And then 2A is how I understand the state intends to proceed, and I think they're right. That the defendant altered, destroyed, concealed, removed any other item, and in this case, the information alleges blue jeans, with the purpose to impair its verity, truth. I don't know if that applies in this context, but seems to be more of a documentary or statement type element, or availability in such proceeding or investigation. And it's going to be the defense's contention as one of her theories of defense, that whatever she did not impair the genes' availability or verity in the trial. And as a function of that, how do you know? Because the genes were submitted to the FDLE for an analyst that took 9 different cuttings, swabs, all of this. There was plenty of gene evidence and DNA evidence that couldn't be, in some categories, due to the limitations of the protocols, and we'll get into that this afternoon. But due to the limitations, they couldn't get it. DNA was there, but it was uninterpretable. And there was no interpretable DNA evidence, and that's the basis by which we can argue that she did not alter, impair, or diminish in any capacity the evidence. I would also note that on the standard in jury instruction, it has a category 2, and we'll have to wait to see how the evidence is presented, but there's an intent. And so there's very good argument available to the defense that perhaps it's an attempt, ladies and gentlemen, that this happened, but it didn't impair any evidence from the testimony that you've heard. There was no impairment of the availability of this evidence. It may be an attempt, but nothing more. And so to limit our ability to argue to the jury that that we can't get into whether the genes were in fact altered or impaired undermines one of the primary tenets of the defense in this case. It would be improper. Now, I've provided the state, if I may approach, I have a case from the court. And once again, like just about everything else we've had in this case, nothing's on all fours. But I furnished to the court a copy of the case Boggess, B-O-G-G-E-S-S v. State 269, Southern 3rd, 616. This is a 4th District Court of Appeal from 2019. And in this case, there was an appellate issue that was taken up by the state the state responding to the defendant's argument on close that that they didn't produce sufficient evidence to establish one of their affirmative defenses. And I'll direct the court's attention to page 6 of the printout. This would be page 621 of the reported decision. And it's talking about the argument of the state, closing argument. It had notes 11 or 12. This court reviews all 3 statements in the context in which the statements were made. The comments, when taken in context, were an explanation of the lack of evidence supporting Bogus's, the defendant's theory of defense. Reversing the parties here, the same argument applies with respect to the defense. What we would intend to argue is, taken in context, the fact that there was no DNA recovered from these genes is an explanation of the lack of evidence supporting the state's theory that they were altered, diminished, unavailable for this proceeding. And I think it's fundamentally baked into the case that this is a matter for the jury to decide, and it's fair game for us to argue. She's free to argue that our theory is ludicrous. Well, without denigrating the defense, I suppose. But this is a matter that's squarely in front of the jury because we're entitled to argue that she did not alter, destroy, impair the availability of evidence. And how do you know? Because you have this DNA evidence that was unable to be recovered, in large part through nothing of the condition of the item of evidence, but the protocols and limitations of the DNA testing. And so this would be fundamental. It's a matter for the jury to determine, and it goes to the weight of the evidence, and we should not be deprived of making that argument to the jury. I would also note that one of the cases the state relies upon, with its Costanzo v. State, and the court may recall that case from a prior proceeding in another county. In that case, Costanzo, it was a law enforcement officer that had video of some evidence involving what turned out to be the victim in the case. The officer deleted it, but it could be recovered from other sources. So contrary to the state's representation, that the statute is clear and unambiguous in that crime occurs when the defendant alters, destroys, or conceals evidence, an item of evidence regardless of how that action may impact an investigation or the outcome of the case, cites Costanzo. Well, a reading of Costanzo shows that's not the law at all. This gentleman deleted the video from his phone. It got rid of it, totally. But because the evidence could be recovered from other sources, he was found not guilty of tampering. In this case, there's the evidence, there's the genes, there's whatever evidence was recovered from it, but it wasn't completely destroyed. That's the state's theory, and they can argue that. But likewise, the defense had the ability to assert its theory of defense that there was no alteration or destruction. And in this case, it was destroyed by this defendant. And so the law cited by the state doesn't support their contention, because in that case, the destruction, regardless of whether it had an effect on the case, or as the state put it, regardless of how that action may impact an investigation or outcome of the case, they said, well, there was other evidence. So even though he destroyed it, it doesn't impact the outcome, it's impermissible. So in this case, it's our contention that this is a matter from the jury. It's a theory of defense that would be asserted by the defendant, and to limit our ability to argument on the quality of evidence would be reversible error.
All right.
Here, just to respond, so I'm clear, I'm not saying, and Mr. Kaczurkas can argue all day long that Ms. Smith did not alter, destroy, or conceal those genes, if he likes. And it seems like splitting hairs, but what he's been doing through the deposition and perpetuation of Ms. Hoover, and so why I'm trying to anticipate this argument, is he's going beyond that. He's saying, or I anticipate he may argue to a jury, and all I'm trying to prevent is an argument that whether or not she affected results or not, it doesn't bear on whether she altered, destroyed, concealed, or removed a piece of evidence. And Costanzo is quite different factually from our case. It doesn't change the law the court must rely on. But as your honor knows, in Costanzo, the reason why they held, because he would have been charged under a theory of destroying, right, or getting rid of this video, the reason why they said that this should not be criminalized is because the defendant had already texted that video to somebody else, emailed that video to someone else, and shown. So that defendant knew he was destroying that copy, clearly, but under the specific intent at that time, that video was out there. The exact copy of that video. We don't have another pair of American Eagle jeans in the original form they were in. It's quite different. So I'm not aligning the facts. The way they looked at that case, he was charged under a different theory of destroying, completely destroying or getting rid of one piece of evidence. And so they didn't want to criminalize that because that defendant knew that piece of evidence, that exact piece of evidence, a copy of it, a digital piece of evidence existed in other places. We didn't have an exact copy of those American Eagle jeans, how they arrived in that house at 3 a.m. off of Aidan Fauci's body. And what we're charging is that she altered those jeans, period. It doesn't matter if she was successful or not successful. That's the law, and so I'm just trying to prevent it. I'm not trying to go against his theory of defense. He can argue all day long. She didn't alter them. That's fine if that's what they want to argue. But it would be like allowing, in a case where it's not a lawful defense in, let's say, an L&L case to argue consent. You would never allow a defense attorney to argue consent in a case where that wasn't the state's burden. The state doesn't have to prove whether a child in that case consented or not. It's not the law. And so here I'm just trying to prevent any argument that whether or not she is successful in her ultimate quest in destroying, altering an item of evidence doesn't matter. That's not the law. I don't have to prove whether or not she was successful based on the action she took against the piece of evidence. That's just not the law, Judge.
Can you restate that? I mean, the instruction says alter, destroy, conceal, remove.
Right.
So what is it that you're saying that you have to, that you would be proving that
It was altered, that the jeans were altered,
The jeans
that they
were
were
altered.
destroyed, concealed, or removed?
The jeans were altered.
So you are saying that they were altered.
They were, right. That would be our argument. They were altered and they're,
Well, just a moment ago, you said that we're not gonna have to prove that.
no. And I said he can argue that she didn't. I'm not, because he just said the state's trying to prevent us from arguing that she altered and destroyed all this stuff. No, she altered the jeans. She removed blood. He is going one step further and getting into DNA and DNA results and whether she was successful in whether action A of washing them was successful in changing results. I'm just trying to prevent confusing the jury with whether or not we have to prove that it altered any sort of result or ultimate outcome or the evidentiary value of that item. If a defendant took I'm trying to think of another example, Judge. If the defendant took a cell phone and smashed that cell phone to pieces or submerged that cell phone in water, I think it's common sense and it's a fair interpretation of the statute to say that defendant altered that cell phone. That defendant maybe even destroyed, depending on the condition of the item, which is the cell phone. Now, if law enforcement's able to get in it and do what's called a chip off and get results, fine, or maybe they won't be. But the act of tampering with the evidence has occurred by smashing that piece of evidence or submerging that piece of evidence or altering or destroying, affecting that evidence in its original state. If you can prove with the intent to change its verity, the truth of that item, or its availability to law enforcement. That person probably thinks if I smash this cell phone to death, it won't be available for any sort of meaningful analysis. Well, maybe it will, maybe it won't. But I don't think the maybe it will, maybe it won't has to be proven. And that's why I said earlier, if Ms. Hoover was able, if the genes were in a state where DNA was obtained, it wouldn't change that we would be here right now.
All right, thank
May I respond briefly?
you.
The jury instruction requires the state to prove that the item of evidence was altered. In order for that, and that's a jury question. That's what the jury needs to decide. Was this item of evidence altered, impaired, what have you? If you were to accept the state's argument that we couldn't argue in contravention of that they were altered, you just heard that's their theory of prosecution. The genes were altered. But we can't present any evidence to show why that's not the case. That's in essence directing a verdict for the state. It's completely denying us a theory of defense. Now, what the court hasn't heard yet, and what is likely to hear, is that 3 areas of these genes, 2 were swabbed and there were threads, and then there was a pocket hip cutting that they tried to swab for blood or with the threads get DNA from the blood, and they couldn't. There wasn't insufficient information. It doesn't address I believe it was 9 other areas of the genes that had tested presumptively positive for the presence of blood that were not tested. And so that goes to the weight of the evidence as to whether they were altered, whether that evidence could have been obtained. Because we learned through the testimony that the FDLE protocol, because I don't think anyone at the time that this was going on was thinking about this case. They were thinking about the Aidan Faucci case, and I understand why. But the testimony revealed, well, did you swab the other areas that had presumptive testing for blood and see if you could get that DNA? No, we had it from other evidence, a pair of shoes and a shirt, and at that point, once we have the positives from some other evidence, our protocol is we don't test. Well, that's a matter of weight of the evidence that goes to the jury, not that we can't argue that this item of evidence wasn't altered. And as I indicated before, it's a matter for the jury to grant this motion in limine would be in essence to direct it. The state gets up and says, this wasn't altered. It was fait accompli at the moment the genes were allegedly washed. I can't argue anything in contravention to that? That's insane. And so this is a matter of weight for the jury. The jury instruction says that the state must prove they're altered, and the defense is entitled to argue that they weren't, and let me explain what the evidence is to demonstrate why they were not. That's our position.
All right, thank you, Mr. Gutierrez. I'm going to reserve ruling on this motion. I'd like to hear a little bit more during the trial as far as what evidence is going to be presented during the trial, as well as the testimony I believe that we're going to hear this afternoon regarding the FDLE analyst and what exactly they're going to testify to. I have reviewed the transcript of the deposition of Brooke Cooper, but I'd like to hear that before I rule this motion as well. All right, so it's 11:30. There were no other matters as far as motions, but we can talk for a few minutes about the trial. Some other things that I want to make sure that we're addressing. Jury instructions should be here. Should receive those on Friday. Mr. Gutierrez, as you recall, when we handled the case in Clay County, I required both sides to agree to a rather lengthier statement of facts, statement of the case that I would then present to the jurors to determine how much knowledge they have about the case prior to coming in. So I'm going to direct you all to do something similar in this case. I think that was worthwhile. Helped us kind of get through that jury selection last time. So let's do that again here. If y'all can have that to me by Friday as well. You have a lot of jurors that are coming down here on Monday, so hopefully we'll have sufficient numbers. We will conduct our trial and the jury selection downstairs back in the second floor. It's 264, if I'm correct?
Yes, sir.
264. It's a larger room, gives us a little more space so we can get, we'll bring in 50 jurors at a time is my plan.
With 50 jurors, I haven't had the pleasure of picking in courtroom 264 before in terms of jury charts. You know what the lineup looks like in that courtroom?
Yeah, it'll be 5 to a row, and we'll do 1 through 5 across, and then we'll do 5 rows of that.
Yes,
Or do we do,
The 25 each side?
really, just, how many rows do we have? We have 6 rows, 6 or 7.
6 or 7.
So, okay, the plan right now, I believe, would be 5 jurors per row, 5 rows on both sides,
Split them up and make them.
for 50. I believe that's what we'll do.
Thank you.
All right,
While we're on the topic, what time would you like to see us?
8:30 on Monday. Matters that we need to do.
And Your Honor, and I know we discussed the possibility of one jury selection lasting longer than a day, and with some scheduling conflicts. State would like to open evidence and start on the 17th, that Wednesday. We will be done by the 18th. You can really do that.
That'll be fine. That would be the plan.
Right,
If
right.
you know, if we're not successful, there's a chance we may have to come back the following Monday to continue with jury selection, because I do have another huge panel coming in the following Monday. If we're not able to get our panel on the first Monday.
Oh, so there's not jurors coming in every day that week.
There's not jurors coming in every day that
I
week.
gotcha. Okay.
So we'll see. I think hopefully we'll be all right.
So we'll actually commence the trial that Wednesday.
The plan would be to start openings that Wednesday. And so I believe you all indicated potentially a one-day trial, possibly a second. We'll plan on a second. And if it,
In light of some proceedings that took place last week, I looked at the timer on it. That was an hour and a half, depending on how the court rules, and they cut out very minimal portions of that.
okay,
Given that may be one of the more lengthy witnesses, perhaps. It's possible we could get done in a day, but as I've indicated previously, attorney estimates of time tend to be woefully inadequate, so I would plan on 2.
we'll set aside 2 days, and if the results early, that's fine. We'll plan on 2.
I'm just trying to find out how far out is the client. I'm okay to work through lunch if we can just.
We'll plan on doing that, that's fine. It's 11:30. I'm just gonna, unless there's anything else that we need to address today. We'll just wait for her to arrive. And then
I'll try to get it more precise.
Okay, I'll stay in my office, you just let me know.
Very good.
I'll stay here until we get this done.
Thank you.
All right, we're recessed until further.
Court's in recess.
It's interesting because she's been done for tampering evidence, but what the argument is that the evidence wouldn't have changed. It doesn't change the result of it. So, they're just trying to make an example of her, really, which, it's fair enough. But the only thing that doesn't sit well with me is, like, she just did it to protect her son. I know some people will be like, oh, well, throw the book at her, you shouldn't do that. I think everybody would. If that was your son or daughter or brother or sister, something like really close relatives, and you've seen blood on them, and you're not 100% sure what the hell that is, you could do everything to protect them. So, got a little bit of sympathy for her. I'm not sure what she's looking to get jail term if she's found guilty, which, I mean, she is guilty. So, I mean, in my opinion, I don't think she's going to deny that. Depends on how they act. Right, let's have a look, see where we are. Because this is the beauty of watching stuff after the fact. Oh my god, we're skipping a shit ton. Right? So she's arrived, so here we are, you see. This isn't going to be that long. 2 hours, and it's so an hour and a half. It's about an hour and 10 minutes. Not bad. And there's another one that I might play this. It happened today as well, so I'm not sure what it is yet. I might play it. Depends on timing. Right, let's skip a little bit more then. If we're just watching shuffling papers.
That would relate to this motion, so you can have those in your comments.
Okay.
Right, so we go.
I'll give you one right before the objective question, just for context. When I'm going through general background information about DNA and its processing, I had asked a question, how does blood appear on fabric? There was no objection, and Ms. Hoover answered that. My next question was, how does washed or diluted or degraded blood stains appear on fabric? That was an objected to question based on the grounds that he's arguing in this motion.
How does blood appear?
The original question of just how does blood appear on fabric was not objected
What was
to.
the second question? How does
How
blood?
does washed or diluted blood stains appear on fabric? Is essentially that question, and then she answered it.
Okay,
The second question that I asked was again in general terms, could the washing of blood affect the ability for you to obtain DNA? And essentially, Mr. Curtis can correct me if I'm wrong, and we can go over this again with her, but her answer is essentially, yes, it can. We expect to get DNA results from blood. It is possible to get usable DNA results, but also possible to not get usable results. So she answered it both ways. Could affect it, it also could not, essentially. And then the third question was after we went through the actual evidence with her, and we had talked about the genes, I had said or asked, is it possible that if these genes were in fact washed, that is one explanation of why I know that the DNA results were essentially limited, and she answered it that it is one explanation, and certainly another explanation is that that DNA evidence was never there to begin with.
all right.
So that's sort of the preview of those questions, and so in response to the motion being filed, the state would call Brooke Hoover.
All right. Super, you'll come forward. Pause right there, raise your right hand. You swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
All right. I want to hear that seat of the witness stand, please. Counsel, you may proceed.
Thank you. Good afternoon now, ma'am. Can you introduce yourself to the court?
My name is Brooke Hoover. I'm a crime laboratory analyst in the biology DNA section at the Florida Department of Law Enforcement.
How long have you been so employed?
12 years.
What are your duties in the biology section?
I examine items of evidence for the presence of bodily fluids, blood, semen, saliva. I perform DNA testing on those items. I perform DNA testing on known reference standards from individuals, and I compare the two.
What is your, let's start with your education.
Your Honor, if it'll expedite things, I'll stipulate that Ms. Hoover is a witness that has got sufficient training and experience to offer opinion testimony.
Son?
He can stipulate, but I do believe some of her background and training is relevant to the issue that is of objection, so.
You may proceed.
Would you explain your education?
I have an Associate of Arts from St. John's River Community College, and I have a Bachelor of Science in Biology from UNF. I took courses in genetics, molecular and cellular biology, biochemistry, and statistics. On top of that, I completed FTLE's Crime Laboratory Analyst Training Program, which is about 1.5 years. I have to have 8 hours of continuing education every year. I have to stay on top of that.
Can you approximate how many items of evidence you've analyzed for the presence of DNA?
Thousands.
And you've been in this role, you said, for 12 years?
Yes.
Do you undergo proficiency testing in your role?
Yes.
And how often?
Twice a year.
And have you passed your proficiency testing?
Yes.
Have you ever testified before as an expert witness in the field of forensic DNA analysis?
Yes.
Do you know how many times?
This will be number 66 on the stand for me.
And in what jurisdictions?
In county courts throughout Northeast Florida. I've testified in U.S. District Court, and I've testified as an expert for the U.S. military and the Navy.
Is your laboratory at FTLE, is it accredited?
It is. We are accredited by the American National Standards Institute National Accreditation Board to their standards AR 31.5. We're also accredited to the International Standard Organization International Organization of Standardization, ISO 17025, as well as the FBI Quality Assurance Standards, which are commonly called the FBI QAS. So we're accredited to all three of those bodies.
What type of DNA testing is performed in your lab?
FDLE can perform STR DNA testing and YSTR DNA testing. I'm not an analyst for YSTR, but I can speak to STR DNA.
And is the STR DNA testing method generally accepted by the scientific and the DNA analysis community?
Yes.
And when you tested all the items of evidence in this case, and by this case I mean essentially they were submitted under a defendant's name of Aidan Faucci, related also to Crystal Smith, did you apply that STR testing principles and methods?
Yes, I did.
Are your procedures reviewed and validated in the lab?
Yes, we have accreditors come on site, they review our validations, our procedures, and they're making sure that we adhere to the FBI QAS and that our procedures agree with the general scientific forensic science community.
Ms. Hoover, is blood a good source of DNA?
Blood is an excellent source of DNA. STR DNA testing targets nucleated cells, and blood, liquid blood, has a very concentrated amount of nucleated cells. So yes, blood is a very good source of DNA.
How does that compare to other things you may test, such as sweat, bodily fluids, touch DNA?
Other bodily fluids like semen and saliva, again, concentrated sources of DNA material. Sweat and touch is hit or miss. The outer layer of skin cells that we shed do not have a nucleus, they're dead cells essentially. Sometimes we get DNA, sometimes we don't, but comparing that to bodily fluids are a very reliable source of DNA.
And how does blood appear on fabric specifically in the lab?
Most commonly reddish brown staining.
How does washed or diluted blood stains appear on fabric?
Going back to my training, we worked samples that were known blood stains, and then we would make serial dilutions. So whole blood, 1 to 10, 1 to 100, 1 to 1,000. And what happens is reddish brown staining turns brownish to yellowish, and eventually there's no stain at all, it completely disappears. We've also worked training samples like blood that's exposed to being buried, UV light, flame, certain acids, and we observe the effects of how degrading or insulting these samples impacts DNA results. So what I'm talking about has been within the scope of what I'm trained to do.
And you've done that in training samples, like yourself personally in the lab?
Yes, I have.
And have you seen that in casework as well?
Yes, I have.
Now, is it in general, is it fair to say that washing clothes or our bodies is that concept is understood by the general public without a scientific explanation?
Yes, I feel it is common sense. If you want to get rid of dirt or stains, you wash your hands, you wash your clothes. I don't think that is necessarily a forensic science specific conclusion.
However, based on your training and experience, and based on what you see, could the washing and what you know about blood, could the washing of blood or the dilution of blood affect the ability to obtain DNA results?
Yes, it can.
And why is that? What are you basing that on?
Depends on how much it was insulted or degraded. There's a variety of conditions that can insult a blood stain, and we can still get usable DNA results. To what extent can vary. So I've worked a criminal case where jeans were put through a washer dryer. I don't know the water setting, the temperature, the detergent used, if they use bleach or not. I don't know any of those things. But I do know that in the other case I worked, the jeans were collected from the dryer. They were submitted to the laboratory. I obtained usable DNA results from a blood stain on the jeans and was able to include the victim. It was an example of jeans can be washed and we can get DNA results, usable DNA results, but it's hit or miss. Sometimes we can and sometimes we don't. It varies.
And does that vary depending on, I believe you said what is actually done to that blood stain, and then what, is being removed? Obviously, it can't be seen by the naked eye, but scientifically, obviously DNA is within those nuclei, I believe you said, of red blood cells, right?
Correct. Water, temperature, chemical detergents, heat, these can all impact the DNA and to what extent can vary.
And so based on your experience and training, it's fair to say that DNA results obtained from items that have been subjected to any sort of insult, dilution, or degrading can affect results or cannot.
Correct. It's just a variety of what can happen.
And in this case, you haven't ever, well, you weren't asked in your perpetuation testimony, and it's not your testimony today, that you're not here to testify that the genes in this case were in fact washed.
No, that was not a conclusion in my report or on my testimony. I don't have a test to perform to make that conclusion. So no, I have not stated that.
Now, at the perpetuation the other day, you received a series of studies that were provided by the defense in anticipation of questioning today. Did you review those?
I reviewed 2 studies. One was just an article summary. That wasn't actually a peer-reviewed journal article. I didn't go down, I didn't study that, but I did review the 2 others.
And what were they?
They were both articles on how washing affects bloodstains on clothing.
And they were peer-reviewed and have been published?
Yes.
Okay. Did you, what did they say, and did you agree or disagree with the statements in those studies?
I agree. Both of them were getting known blood and putting it on sterile fabric and subjecting the fabric to different washes at different temperatures, and then taking a sample and seeing what the results were. And they both showed that the higher the temperature, you get less and less. One of the studies, although it called it a partial DNA profile, FDLE would call it limited non-interpretable, and the study did get down to where you don't have DNA results at all. I don't disagree with any of the information presented in the studies. It showed the effect of washing on bloodstains.
Okay, and in those studies, it actually provided that back DNA data, I'm saying it wrong, I'm not sure, the electropharogram
Yes,
data that you
Yes.
understand and can interpret.
yes.
And in those studies, did they get some DNA
They did.
throughout? And you just mentioned, if you were interpreting that data in those studies for purposes of casework under FDLE protocols, you would have to testify that some DNA was obtained, correct?
Correct.
Would that DNA have been classified as what you call limited non-interpretable?
One of the electropharograms, it was a swatch of fabric with a blood stain that was washed in 90-degree temperature water. That specific result had an electropharogram with 3 called peaks. That does not meet our minimal definition for a partial profile. Our interpretation of that would be limited non-interpretable. And again, this was an experiment where they knew the blood of the blood was from a known donor, and they knew that there was no background interference because it was a clean, sterile piece of fabric. That's not what we're working with in casework.
And so how you apply that in casework, or scratch that. So you don't disagree with the studies at all, correct?
No, not at all.
And in what you saw, some DNA data was obtained.
Correct.
But in your view, at least in that one example, would have been reported out as limited, uninterpretable.
Yes, the results for the 2 samples washed with 90-degree water, one FDLE would report as limited non-interpretable. The second one, because they did it in duplicates, the second one was no DNA results at all. So I agree with the study, like washing can remove DNA to different extents.
Right. And in that case, at least in the studies, that's obviously a controlled environment. They deposit the blood there, they know it's there, and you would expect to get results. Is that fair? If it was not altered.
Could you ask me that again?
Essentially, in that study, that they're doing it in a sterile environment, like you said, it's a
Controlled
clean
environment, yes.
piece of fabric. They deposit blood.
Correct.
And would you expect to get DNA results in that scenario prior to any dilution or washing?
Absolutely.
And is that based on why? Why would you expect to get results?
Because it's a known sample of whole blood, and the amount that they put on that fabric, usually a blood stain that has not been altered, that is visible to the human eye, you would typically get DNA results from that, usable DNA results from that.
Okay. And so ultimately, in this case, there was various different categories of results, I would say, from the genes. Is that right?
That's correct.
The one that we're here about today, that the defense is objecting to you answering questions, specific questions on and answering, is a category of results that you reported out as limited non-interpretable. Do you recall that?
Yes, I do.
Okay. And so do you recall that there were, what areas of the genes were limited non-interpretable results? Or what pieces of evidence from the genes?
Yes, that was round 3 of testing. The first round, I took cuttings, and I got mixtures that were ultimately not interpretable. I went back a second time and took additional cuttings from different areas. Those were mixtures that were not interpretable. So I changed the tactic. I wanted to try a different sampling method to overcome the challenges that I was experiencing with the results. So I went back, and instead of taking cutting, I took a swabbing, which I know will collect less DNA than a cutting, but I was also hoping that I could just pick up blood and not get background interference from wearer or any kind of transfer from any washing potentially. So yes, I took 2 swabbings, and I also took apart the back pocket of the jeans, and I pulled the threads out because, again, I'm trying not to get background interference from whoever may have worn the jeans. I just am interested in obtaining results from whoever was bleeding. So I went back, I took the sampling methods, swabbing threads, and I didn't get usable DNA results because it was limited.
You got DNA results,
Yes, I did get DNA results.
but the limited amount of data did not allow you to interpret them.
That is correct.
Okay. And when you were asked if the genes were in fact washed, could that be one explanation for limited data? Your answer would be?
It could be, yes. And again, I never stated an opinion or stated they were washed. It's possible that they were washed, and that's why I'm not getting DNA results. It's possible it wasn't there at all to begin with, and I'm not providing an opinion on to which is more probable. I don't know what happened to those genes before they got to me.
No further questions, Sharon?
Cross-examination.
Good afternoon, Ms. Hoover.
Good afternoon.
In this case, you had discussed in your training as well as a case study that you had encountered items of evidence that had been washed or somehow diluted, correct?
Correct.
Did I understand your testimony to be that you only had one actual live case study where that was an issue?
That went to trial. I've probably worked more with the volume of casework I've done. I'm sure I've handled other cases where there was an attempt to dilute or conceal that opened items of evidence and smell bleach before. But what I was talking about was a case that I remember because it went to trial.
Is that the only specific case that you can cite that you had that facet present?
That I can recall, yes.
So you've had one case study and then this was encountered in training.
Well, it wasn't really a case study, it was casework. It was actual casework where I encountered this. And yes, and training.
You remember the name of the defendant in that case?
I do not. I remember it was Alachua County. I remember that it was a robbery where a victim was shot, but I don't remember.
And the other times you've been exposed to items of evidence would be in training scenarios where you were instructed that these items had been washed or somehow diluted.
That, and I've also been a principal instructor for training, and I've prepared the samples myself for other trainees. So I've been involved in both testing and preparing and seeing the results that my trainees have gotten with those samples.
Now, on direct, the state asked you about a series of studies that were raised at the first round of this hearing, if you will, that you were not present, but you got the benefit of the studies that were submitted to the court.
That's correct, yes, sir. I did
Okay.
get copies.
And repeatedly in the course of your direct testimony, you talked about the studies up to 90 degrees, correct?
Yes, one of the studies, I could pull the paper to quote the title, but it was, the fabric was washed in 30, 60, and 90-degree water, and they then took DNA sampling from that study.
Now, those degrees were Celsius, were they not?
They were.
Okay. And so for the benefit of the court and lay people in general, that one study that had the 3 different washings at 30, 60, and 90 degrees Celsius, they could not produce DNA results at 90 degrees Celsius, correct?
Incorrect. It produced DNA results at one of the attempts did provide DNA results, but by our interpretation, those results would be limited, not interpretable, because there were only 3 peaks called. The second 90-degree wash had no DNA results at all.
In any event, you would agree with me that 90 degrees Celsius is 194 degrees Fahrenheit, would you not?
I can't do that without a calculator. I don't wanna do conversions on
Is there a phone and a calculator built into it? Do you care to do it?
I don't know the formula off the top of my head.
Okay, I think that's built into the app if you'd like to try.
If it pleases you, go right ahead. I don't wanna do a conversion like that in my head on the stand, on the spot.
Bear with me one moment. You don't know the conversion for Celsius to Fahrenheit?
I don't have it memorized. I don't need it for what I do, but it is something I could look up.
And then that's what he's doing and
The conversion for Celsius to Fahrenheit.
She's already said she doesn't know the formula. Are you gonna just tell her the formula and let her do it?
Or we can research it and find out.
If you want to confront her and ask her, that's fine.
She's already, in case she doesn't know it.
And I think another thing mentioned in the study was they didn't alter the washer or dryer setting. So I would assume, to explain to a layperson, this is cold water, warm water, hot water.
But in this case, you were advised prior to your performing laboratory work that these jeans were allegedly washed under a sink.
I did have information that the clothing had been washed, yes.
In a sink.
I don't know, I don't think I knew that. I knew that they had been washed, but I don't know how they were washed.
Okay. Well, your perpetuated testimony will reflect what you knew.
Okay,
You would agree with me that water flowing from the sink in a residential home doesn't come out at 194 degrees Fahrenheit, does it?
it's about boiling. I don't know what they have their water heater set at, but I don't think it would come up that hot.
Actually, boiling's 212 degrees Fahrenheit, is it not? Slightly under, but it's still not coming out at near boiling, is it?
I'd have to look at those numbers. But again, that's not something we look at in forensic, that's not coverage we do relevant to forensic science. Like, we're not making those conversions for our casework.
Well, if you were testifying in front of a lay jury, you'd be using Fahrenheit, would you not? In America, anywhere?
I didn't make any kind of conclusions of temperature in any of my reports.
Turning to the DNA testing you did perform, in your testimony in your report, there were, let's call it 3 buckets of DNA, correct?
3 buckets?
Yes, there was one that was mixture not interpretable due to not being intuitive, correct?
Okay, we're talking about the results. So yes, mixture, UDM, undetermined number of mixtures. We had complex not interpretable mixtures. We had mixtures that were limited not interpretable, and we had limited DNA results.
Well, that was 4, I thought there were 3.
There were 4 different categories, or 4 different reasons I couldn't interpret the data.
Let's break those down. The first category of various fabric samples that were cut from the DNA, you were able to get DNA results.
Yes, I got DNA results from all of the samples I took.
Okay. And then that first category, there was a mixture, correct?
Correct.
However, when you were looking at the data, the electropherogram, that data was not intuitive to you, correct?
The electropherogram is just the data. That's just the data. What was not intuitive was our probabilistic genotyping software's interpretation of that raw data compared to what I know, because I know I was dealing with relatives in this. So yes, where people share alleles because they are related, the DNA will appear higher, and you had previously called it stacking. So yeah, where relatives share DNA, those peaks will be taller in height. And where the relatives had one allele in common and one allele different, the peak that they shared would be very, very tall. The peaks that they didn't share would be shorter. And what the software was doing was it thought that there was a very, very high contributor, and then it thought the other contributors were very, very low. That's not actually what was going on. There were 2 contributors with nearly equal contribution, and then the other contributors were off in the weeds. So we don't just use software as a black box. We put in data and it spits it out and we're like, we accept it. We have to review what data or what the probabilistic genotyping software tells us, compare it to the electropherogram, and make sure that this makes sense. And going back to accreditation and validation and procedures, this is part of the scientific process that has been validated and written in our procedures.
Understood. But the limitation on the interpretation of that data was a result of the lack of intuitive results being produced by the software, not anything due to the item of evidence itself, correct? With those swabs of fabric?
That was the condition the item was in when I got it. That was the data.
I understand, but there was DNA there, the results just weren't intuitive. It wasn't, there was missing information, correct?
There was unintuitive information. What the software was telling me about the mixture, specifically mixture proportions, was not intuitive. And I know that was because I'm dealing with relatives in mixture.
Relatives in a mixture, not due to an absence of interpretable data. The data just was not intuitive, correct?
The data was not interpretable because it was not intuitive. And the reason we have procedures for handling data like that is we know that we could falsely include or falsely exclude a person of interest from a mixture where we have this type of data. It doesn't mean that every mixture we obtain with relatives is uninterpretable. That's not the case.
I'm not saying that.
But in this case, with these samples, I would not want to go forward and use those because it's not technically correct based on validation and procedure. And the reason it's not correct is because we could apply the wrong likelihood ratio, falsely including or falsely excluding an individual from results like that.
Fair
It's
enough.
not usable.
Fair enough, but we're here talking about a case where an item of evidence is alleged to wash, rendering your job more difficult in obtaining DNA results. With
And-
that category of evidence, that wasn't the issue, was it? The genes being washed. You had data, it just, due to the system not recognizing related donors with allele stacking, it was uninterpretable.
All of the data from the genes was not interpretable for a variety of reasons with the variety of sampling methods that I took on multiple attempts to get usable DNA results from the genes. I have no test to tell me that those genes were washed. That was just the item and the condition that I got it in, and that was the data or the results from samples taken from that item of evidence. That was the data.
Do you recall having your deposition taken on April 25th, about 2 weeks ago?
Yes.
May I approach?
You may. Okay.
Ms. Hoover, if I can direct your attention to page 28, line 9. And if you need to read the portion of the deposition before that, feel free. This is a portion of that deposition where we're talking about my parlance, the first bucket of DNA results. You with me?
Yes, sir.
And I asked you the question.
I haven't heard the question yet. What is the objection?
The method of impeachment, he needs to allow her to read and tell her director of the section she needs to read before he asks her any questions about it.
You may proceed.
Now, and if you need to back up to put this in context, that's fair, but I'll represent to you that everything before line 9 on page 28 relates to this first category of DNA testing that we've been discussing. And then I asked, question, and that was based upon the results the software was producing. Answer, correct.
Again, objection to proper impeachment.
What's improper, counsel?
He's asked her to review the question and answer and then ask her if she recalls giving it.
Is he refreshing
He's
her
just reading
recollection?
it, I don't
Is he
know.
refreshing her recollection, or is he impeaching?
I'm not sure. He's just reading things on the record.
Sure.
I'm impeaching her. If we get to the next question, you'll see why.
You may proceed.
Next question. Put another way, it's not because of anything that happened to the sample itself, it was the limitations of the software. Answer, correct.
Yes, and we did talk about this in testimony. Since April 25th, since we had the deposition, I did undergo continuing education with the developers of the StarMix software. I had a 2-day course with them in which the developers of the software, who were based in Australia and New Zealand, were live with a small group of analysts, and we were able to go over the ins and outs of the software. We were able to go over courtroom testimony and things that the software was capable of. And I said, based on that, and this was in testimony, I said, based on that, although I said in the deposition it was a limitation of the software, I said when I testified, I would like to say that it is not a limitation of the software, but how FDLE uses the software.
But not the condition of the item itself, correct.
The
That's what,
item was the condition it was in when I got it. I'm not saying that, I never concluded or said that because it was washed, I didn't get results. I've never concluded that, I'm not saying that. And I feel like you're trying to get me to say that it wasn't washed and that's why I got results, I'm not quite sure.
no, what I'm trying to get you to say is what you previously testified to, that the results that you were getting with this first batch of DNA results were due to, however you want to characterize it, limitations of software, FDLE protocols for interpreting software, what have you, not due to the condition of the item. Correct?
UDM is, that was the condition of the item, that was the ratio of DNA types that were in that fabric when I got the item, that was the condition of the item. Like the ratios of the donors, that's just how it was.
I understand, you get whatever you receive,
I get whatever I receive.
but when the results are produced, you're looking at it, it had DNA, it had sufficient quantities of DNA to interpret, they just weren't intuitive.
Some of them. So I did get UDM, or undetermined number of mixtures, which I went back and I got more samples. Like, this isn't something I want to interpret I'm going to try again. So yeah, I did get some samples that were UDM, and I'm like, you know what, I'm not going to interpret this. I'm going to do additional work. I'm going to go back and take more samples. And I did. And I didn't get usable DNA results from that round of samples. So I went back and got samples in a different method. I went back again. So UDM, that wasn't the end all of the testing. I went back and tried again. I went back and tried again. I put a tremendous amount of effort in this, and we did stop attempting to get DNA results from the site.
We'll get there. The other bucket, as I call it, was a sample that was returned as a mixture. Are you following me?
Yes, sir.
However, the data that was produced suggested it was more than 4 contributors, correct?
It was 4 or more. And again, sharing with relatives, I couldn't say for sure that this was a mixture of 4 and only 4 people. There could have been 4, there could have been 5, but I'm dealing with relatives. I was not comfortable making a determination in how many people were in this mixture, but there were at least 4. So yeah, I call that mixture complex not interpretable because there were 4 or more donors.
Once again, that was due to the limitations of the software, the system, FDLE protocols to allow you to interpret that.
No, with UDM, I actually did use the software as a tool for helping me determine number of donors. I used the software and I tried those samples as 3-person mixtures and 4-person mixtures. I reviewed the output to try to help me determine if this was interpretable data. So yes, I used the software, wasn't giving me interpretable results. This sample, I did not use the software because I didn't need to. I couldn't determine how many people were truly there. It never even got to the point of using software. It was, in layman's terms, a hot mess. I just couldn't use it.
Put another way, there was too much DNA or too many contributors to allow you to interpret.
Too many contributors and possible sharing due to relatedness among the contributors.
And then the last bucket, as I refer to it, is the limited results not interpretable. The swab, and that was on the front left pan, correct?
Yeah, one of the swabs was from the front, one of the swabs was from the back.
The right rear back pocket
Right in
area.
the back pocket, that's where I could see the most staining left.
And then there were threads that were also pulled from that area.
Yes,
And then there was a right hip pocket piece of fabric that was tested in this bucket, correct? Shall I just give the report?
I don't remember, I swabbed the fabric, I didn't take cutting.
Okay.
I sampled fabric, yes, by swabbing it.
And you took one swab from the front left leg,
That sounds right, yes.
one swab from the right rear,
You
Right.
right rear buttock area, yes,
and then the threads, as you recall.
yes.
And those results, unlike the first 2, didn't generate enough data to interpret.
Correct. I was getting too much information and I changed my sampling method to try to overcome the challenges that I was facing. So yes, a swab doesn't pick up as much DNA. I'm swabbing, hoping to absorb whatever skin cells are on top of that substrate. When you cut a substrate, you're taking that entire matrix of that fabric with whatever cells are in it. So yes, I took a swab in hopes of getting less information because I was getting mixtures. And this 3rd round of testing also did not produce usable results, but for different reasons.
And how many areas of the pants that you conducted the presumptive blood test, how many areas of the pants tested positive?
I don't recall, I would have to go to my notes. I don't have that information memorized. But there were many areas of interest that I circled on the item, and every area of interest where I could see staining tested positive for blood.
I have a
Presumptive test positive.
I have a copy of your notes if you want to be precise, but would you disagree with me if I told you it was 9?
I took mine for testing. May I pull up?
Absolutely.
May I refer my notes? I'm counting 9 areas.
9.
I'm sorry. 1, 2, 3, 4, 5, 6, 7, 8. I'm sorry, I'm counting 8 areas. 5 on the front, 3 on the back.
I apologize, 8. So there
Okay.
are 8 areas, and you swabbed 2, correct?
I swabbed 2, that's correct.
You didn't swab the other 6.
No, I did not, I took cuttings from several of them, but, and also when we're referring to stains, this isn't like a little dime-sized spot, these are large areas of the pants that were circled.
Nevertheless, you swabbed 2 of those areas.
I did.
And how many times, when you got the results back from these swabs and the threads and they limited data, not interpretable, did you go back and try it again?
No, at that point I did not.
And what's your training scientific method if you try something once and don't get a result, are you instructed to try it again?
I'm not instructed to, but on the first round of testing, and I didn't conclude this in my report, I'm not testifying it because I couldn't make the conclusion, but my training, I could see the person of interest in those mixtures. And my training, my experience, I thought it was worth it to go back and try it again.
Well, isn't it true that you didn't further test because you got positive results for Tristan Bailey's DNA on a pair of shoes and a sweatshirt?
Probative results, yes, that's true. Yes, that is correct.
And so under the FDLE guidelines, when you get those positive results from other item evidence, you terminate the testing, do you not?
Not unless there is a reason and communication over my head about what to test. But no, we don't exhaustively work every item of evidence. You could perform thousands of DNA tests on a big pair of jeans like that. At a certain point, we have to realize we're good stewards of Florida taxpayers and resources. We can't just exhaustively work an item of evidence, especially when we have Tristan Bailey's blood on the shoes, blood on the shirt, it was a mixture, Tristan Bailey was included, blood on the shirt, that was single source, and it matched Aidan Faucci. We ceased testing on jeans.
When you got those results?
I actually went back after I had those results and tried again on jeans.
But you swabbed 2 areas once.
That's correct. On the 3rd round of testing, I swabbed 2 areas and I took threads.
And those were limited.
Those were limited, yes.
But the areas of fabric from which you took those swabs, when they were tested, there was DNA. The protocol wouldn't allow you to interpret it.
Correct. And going back, the reason we have these protocols is validation, procedures, all of which is through being an accredited laboratory. This isn't FDLE out on a wing. This is generally accepted mixture interpretation by the general scientific community.
Understood, but in this case, there was DNA, you just for the protocols and the validation, you couldn't interpret it.
I would not interpret it. It was not interpretable by protocols and validations procedures, no.
Not because there was limited data.
Not because there was, it's not all of them were limited. Some of them were a lot of data, but for different reasons, none of it was interpretable ultimately.
No, but the 3rd bucket was limited data.
Yes,
The other 2 didn't have that problem. They had other issues.
they all had challenges, correct.
But the only one we're focusing here on today was that 3rd, the swabs and the threads.
Correct. I would normally expect to get DNA results from a swab from a blood stain.
Normally.
Normally, under normal circumstances, yes.
But your testimony, it was possible it was once there and is no longer. It's possible it was never there.
Correct.
Another possibility is you didn't swab it sufficiently to get DNA sufficient to test. It's possible, is it not?
I don't think that's a possibility because I took cuttings and that was too much. Swabbing was too little. There were challenges with that sample
So
or with that item.
human error is not a possibility in your opinion.
In this case, no. All of my results, my sampling methods, all went through a technical and administrative review process.
That may be, but you didn't get sufficient DNA from the swabbing, correct?
I did not.
Okay. And it's possible that that could have been operator error.
I don't think so. I really swabbed these jeans.
One time in two areas.
Correct.
So certain things are possible, but other things are not possible.
I don't think human error on my part or on the lab's part had an impact on the results from the cycle of evidence.
Okay, that's what you think.
That's my opinion, yes.
Okay. Do you have an opinion whether the uninterpretable data resulted from the condition of the item of evidence as to the two swabs and the threads?
Again, it's possible that it was there and it was removed. It's possible it's not there at all. But ultimately, I would not give opinion as to what I think is more probable. I would let a jury make a decision with other factors available to them. I don't want to say what I think is more probable. I would just say both things are possible and leave it up to someone else to make that decision.
I'm gonna have a moment.
Okay.
Nothing further.
Redirect?
Just briefly, guys. It just got a little confusing towards the end. I just want to make sure the court understands, in your first round of testing on the genes, that was when you took cuttings, correct?
Correct.
And you took 6 of them, correct?
In total, correct.
From different areas on the genes.
Yes.
Then the second, what was the second round of testing?
First round of testing was 3 cuttings. Second round of testing was 3 cuttings from different areas. Third round of testing was 2 swabs and the threads from the pocket.
And so it wasn't that you just took 2 swabs from these genes and stopped, correct?
Correct.
And then just, I wanted to correct one thing, and I believe you did, Mr. Katurgis had asked, when pointing out you did get usable results from other items that were located in that house pursuant to the search warrant. You mentioned the shoes. And then you mentioned, he said the word sweatshirt, I believe you corrected him, I just want the record to be clear, was it a shirt you were talking about?
Yes.
That included Tristan and
Included Tristan
Mash.
and Mash Aiden is the language, yes.
Okay. All right, now I have any other questions.
All right, Ms. Wood, be excused.
Yeah.
Thank you very much for your review. Any additional,
Thank you, Sergeant.
anything else from the defense?
Same, just argument.
All right, sir, motion, Mr. Church, I'll hear from you first. We'll allow the witness to exit the room. Thank you, Mr.
All right, Your Honor, it's our position that the testimony as it related by parlance, again, the third bucket of DNA testing, the swabs from the fabric and the threads, to allow Ms. Hoover to testify to that with the imprimatur of expert credibility, it just exceeds the bounds of expert testimony. In the case, there's fabric, 3 different types of DNA results based upon the testing of the fabrics in the first 2 buckets, and then the swabs and the thread in the third. We know there's ample DNA from the first 2 buckets that they were uninterpretable, and the testimony will speak for itself as to why. With this third, there is limited results uninterpretable. She can't say why they're limited, but only possibilities. And I found it fascinating that a possibility is, one, it was once there and then since removed, the state's theory of the case. It was never there, but the possibility of human error just doesn't exist. She's perfect. This is well beyond the bounds of expert testimony. It's guesswork. It's possible. This is beyond 702. And I'm not suggesting that the state can't make the argument, but to have this come in through an expert witness that is mere speculation and guesswork is a bridge too far. And we've provided the cases previously to the court. They were argued in the first round, the Perez versus Bell South Communications, 138-492, 3rd District from 2014, talking about Daubert. And expert testimony that otherwise may qualify as pure opinion testimony is strictly prohibited. The legislative purpose of the new law is clear, to tighten the rules for admissibility of expert testimony in the courts of the state. And subjective belief and unsupported speculation are henceforth inadmissible. Whether it was once there and since removed, it's possible. Speculation, was it never there? It's possible, it's speculation. Likewise, Royal Caribbean Cruises Limited versus Spearman, SPAEARMAN, 327 3rd 276. Once again, found that the expert testimony in that case exceeded the bounds of Rule 702 in terms of the alternative design. This was the case with the two-issue rule, and so it wasn't reversing, but it did address the expert testimony, finding that it was too speculative to be admissible. And then we had the Vitelli case and the state of Furnishing and Barber, that Dr. Goldberger's testimony regarding extrapolation was admissible, but it gave the standards. And in this case, there's no scientific study as to why, it's possible that we tested it. It's just guesswork, speculation. It's possible. And if it's a layman argument, they don't need her to present it. They can argue it. If it's common knowledge, if it's subject to the layperson's understanding, you don't need Ms. Hoover for that. But that's what the state's trying to do, is bootstrap what they consider a lay opinion under the guise of expert testimony to present it to the jury as such. And we find that that exceeds the bounds of 90.702 Florida statutes, as well as Dauber and its progeny.
Thank you, Mr. Chair.
Your Honor, I know this motion was filed before, again, like I said, kind of before counsel heard her trial testimony, but we now have the benefit of that. And I'm sure counsel may not have known how far and how deep the state was going into these matters. So in the light of the three questions that were actually objected to in the motion today, this isn't a dog. I don't feel Dauber is the proper objection and analysis for the court to do, now having seen the arguments and knowing now the questions the state asked. The witness is clearly speaking within her scope of expertise and discipline in answering these three questions. And I want to remind the court again, one, of the first question that the state ultimately asked her was, how do washed or diluted blood stains appear on fabric? That is information and knowledge within our expertise. That doesn't call for a Dauber objection, because again, we're not talking about a method of testing that he's challenging or anything like that. Now, could he make a objection on outside of scope? I believe would be the proper objection if he was to make one there. And then our response is her knowledge about blood, which is why I asked her that line of questioning, how it appears normally when it's unaltered, how it looks after it's unaltered. I believe she said it goes obviously from reddish brown to light reddish brown to yellow eventually, or not present at all. In her perpetuation, she also mentioned sometimes it appears green. So she knows that based on her training and experience, and it's clearly within her purview. That's not a scientific method testing Dauber objection. And so in response to any other objection outside of scope, it's clearly within her scope. The same applies to the second question. And again, involves her scientific knowledge and understanding of DNA and nucleus and where DNA comes from and in blood. Could the washing of blood affect the ability for you to obtain DNA? Yes, it could. That's all she's saying. It could, and here's why. And she goes on to explain the testing examples that they do in training, how she has received them as someone being tested, and she has actually done the examples herself and prepared them for other people to test, and then in casework. So she has training and experience within her discipline to answer those two questions. It's not a Dauber objection. And we believe that those are obviously completely allowable based on her training and experience. However, because she does have specific training and experience in working with blood and blood samples that have been compromised and how they appear on fabric, again, she's able to answer those types of questions. That third question is just, is it possible that if the jeans were ever washed, and the state even asked the question in a way, knowing that she's not here to make any sort of ultimate conclusion, but I asked the question, is it one explanation on why you may not receive usable or enough DNA information? Now remember, it's that third category, it's the limited, where there wasn't a lot of DNA present. She obtained some DNA, but not enough. And she testified it's one, I mean, she has to, it either was there and removed or it was never there, and that's how she's answering that question. Again, not really appropriate for a Daubert objection. I believe the more appropriate objection is outside the scope, and it's clearly within her scope to answer that question. Mr. Contreras raised, well, they don't need her to say that, and I pointed that question out on purpose. There's a basic, some of this is common sense, you can watch something and either remove it or not. But combined with her knowledge about blood and knowledge about DNA, she does go a step further, and she has training and experience. So for her to not be able to testify how blood appears normally, how it appears when it has been diluted, and then whether the washing of DNA could affect your results, that is as far as the state went. Was never gonna go further than that. I'm not asking her to testify as the ultimate issue in this case. And that's the extent of her testimony as you've heard today. And so she simply explained what she knows about blood stains, how they present on fabric, how they may appear if they're diluted or degraded, and how that may affect results. And I believe Mr. Contreras would agree with me that that is how the state posed it in its perpetuation. That's how she answered it in the alternative. I understand he's still objecting to the answer, but that is how we presented it, never trying to imply that she had tested these and could say they were in fact washed and how or anything of that nature. And I believe she's well within her scope of expertise. And I don't believe it's a true Daubert analysis. It's a different type of analysis for the court to make, whether it's relevant, it's within her scope of any expert, but not a Daubert issue here. He's not challenging any scientific method or whether any particular thing she did is generally accepted. I laid some of that predicate just to show that her general testing methods and what's done in the lab is obviously generally accepted, but as to these specific questions that were asked, it's not a Daubert issue.
Well, what's your choice?
I'm not sure how the state can have it both ways. That she's qualified to provide this testimony based upon her training and experience, but this isn't a Daubert issue. I don't know what the right objection is. I've made the ones that I thought were appropriate. It's beyond the scope of her expertise. It's guesswork. It's possible, but the state wants to buttress that with all of her training and experience that she can render this opinion. That's a Daubert objection. If they're using her qualifications, her background, her training, her experience to be able to render that opinion that it's possible, that's a Daubert objection. And it's not based upon any empirical studies. The only empirical studies we know of, you can extract DNA up to 194 degrees Fahrenheit. So it's improper expert testimony. They're using her qualifications to put before the jury mere speculation. It's possible. It's curious that the only thing that isn't possible for this witness is human error. And so on that basis, we would object to her speculating as to why she did not get certain results when she tested these swabs once.
Sure. Let me just ask you, we're dealing with DNA evidence, fingerprint evidence, decades. How is this any different than any other FDLE analyst or any other expert that comes in and testifies to, let's say, negative DNA results? We've seen, that you've been in trials where the state will call an expert to put on the fact that they tested the evidence, did not obtain DNA evidence, or did not obtain fingerprint evidence, whatever it is, for the sole purpose of showing that they at least did their due diligence, that they attempted to, and then that witness almost always testifies to the reasons why that evidence was not obtainable, or the reasons that may lead to DNA not being recoverable from certain items, or things that have happened, the grading of evidence or fingerprints and their explanation by fingerprint experts constantly about why fingerprints are sometimes left on some surfaces but not others. Why is this any different?
I think the defendant's position is, it's fair game to say, we tested this evidence, we tried to get it, it was uninterpretable. But when she starts guessing as to why she didn't get, or why she got limited DNA results, that's beyond the bounds of any expert testimony. It's possible. It's not relevant to the case unless you have a specific opinion that I didn't get this because, and I can show you through validated scientific studies that that's what happened. That's permissible expert testimony, but it's possible is not downward. And I can't comment as to what other defense counsel does when an expert gets up and starts speculating. I know what I would do, exactly what I'm doing here. I'd object to it. It's not based upon any scientific data or studies. It's possible. And so under those circumstances, well, anything's possible. And that's just beyond the scope of what they're permitted to testify to. It has to be based upon scientific data that's relied upon by others in the community, that's well accepted, and is based upon data that's reliable. That's the court's function as a gatekeeper. And when you're providing testimony that it's possible, well, anything's possible. It then veers into the irrelevant because you're not providing any direct testimony about why this result obtained. She can testify that we had limited data, uninterpretable. The state can get up and argue, let me tell you why. But to have the expert opine as to that is improper.
Thank you, Mr. Chair. All right, having considered the evidence presented and the arguments of counsel, the court is going to deny the defendant's first motion of limine as to the questions that were presented that were asked during the course of the testimony that was perpetuated, I guess it was earlier last week. Based on at least the questions that I've been presented with today, I would overrule the objections and allow those questions to be answered, so we do not need to do anything with those questions as far, unless there's some disagreement about what the questions were asked.
No, I'm not equivalent with that.
Okay,
Matt, I'm just thinking in terms of some housekeeping.
sure.
We didn't have the benefit of your honor presiding over the perpetuated testimony.
Yeah.
Ms. Dunton and I did our best to simulate going live. So there's going to be, when the video is being played, question, objection, but we don't have the benefit of the ruling from the court. I don't know if Ms. Dunton is of the same mind. We may want to pause that briefly, overrule, what have you. I'm alerting to the court that it's going to seem weird if we just play this without some court interjection into the video.
How do you?
That's fine, we can do it that way.
So we'll pause it when the objection comes up. I'll just
Court rules.
I'll overrule it and then.
Okay.
Okay. As to the state's motion in limine, continue to take that under advisement for right now. I think we just need to hear a little bit more about what happens during the trial. I'm not going to stop you from getting into these things. Just don't make any arguments about, what in opening statements. Obviously, if you're going to talk about DNA evidence and things of that nature, I'm certainly not including you in doing that. That's clear enough for you.
I think I understand.
All right, I believe that's all we've got for today. Is there anything else that we can do from either side of what I've got?
Not from the state.
Anything else for the defense? All right, see you, so you'll have jury instructions to me and the statement of facts by Friday, close of business. Monday morning, 8:30, we'll be present for addressing any matters we need to, and then plan on selecting our jury on Monday morning. Okay?
Yes.
We are adjourned.
Okay, so the plan is to select the jury on Monday, and think that they plan on having it all done Wednesday. So Tuesday will be nothing, and Wednesday and possibly Thursday, and then it'd be done. Well, it's up to the jury then for when they decide. But the only thing that would be like maybe a day's worth of witnesses. possibly going into Thursday, they said. But yeah, I think by Thursday we know the results. So that was just a pre-trial, just to go through the DNA stuff. Essentially, they got the DNA needed, find Aidan guilty, but it would have been a lot easier had she not washed him away. She deserves to be punished for that, whatever that may be. The only thing, obviously, I say I'm not defending her. She shouldn't have done it, but I think anybody would have done it in her position. If your son has trousers who's got, or daughter, whoever has trousers got blood on it, and you don't even know where that's come from, you're always going to be worried. So you're always going to try and, you know, wash them off. I think it's natural for any parent to do that. And so again, not to say that that's the correct thing to do whatsoever, but I'm trying to think of it logically, from a parent's point of view. I think most parents would do that to protect their child. But yeah, I do think she deserves to have some sort of punishment, but I don't know what that would be under American guidelines, really. So yeah, we'll see. I mean, this judge was the same judge that sentenced her son to life in prison, but with parole possible after 20 years, I believe, because he's so young. So we'll see. We'll keep up to date with it. Keep looking at my streams, and yeah, thanks for joining me. And with that, catch you guys later. Ta-ra.